Hello, everybody. Welcome to episode 4 of Law with Darren. Today, I'll be covering the very unfortunate Apple Store crash that happened last week, Monday, November 21st. Very, very sad story. Apparently, on the 21st, the driver of an SUV plowed into an Apple store, killing one person and injuring at least 19 more. According to police, the driver says that his foot got stuck on the accelerator. The driver is a 53-year-old man named Bradley Rain. He currently faces charges of motor vehicle homicide by reckless driving, which is a felony in Massachusetts. Okay, so what happened that day? Well, apparently this guy was driving in the a plaza where there's an Apple store in Hingham. His foot gets stuck, and he drives over the curb, over the sidewalk, and into the Apple store. Now, the Apple store itself is kind of like your regular Apple store from what I can see. It's a lot of glass. It's like every Apple store you've ever walked by. And apparently, lawsuits have been filed by 2 of the families, and I know that there will be many, many more, especially when you're dealing with Apple, against Apple itself, as well as the owner of the property, the commercial landlord. Okay, so as far as these cases go, I've done a little bit of research, and I've found 2 cases on point that I think really accurately show what the plaintiff's attorneys in this case will need to prove. All right. So the first case is a case from 1987. It's called Glick versus Prince Italian Foods. The citation, for those of you who want to look it up online, just type in 25 Mass Appeals Court 901. So what happened in Glick? Well, according to the court in Glick, on November 30th, 1981, an out-of-control automobile operated by a third party left the southbound lanes of Route 1 in Saugus at a high rate of speed, entered the defendant's parking area, which is the Prince Italian Foods, who is the defendant in this case, operates a restaurant. Entered the defendant's parking area, crashed through the solid exterior wall of the defendant's restaurant, and injured several plaintiffs who were patrons inside the restaurant. According to the driver who crashed into the restaurant, his vehicle was struck by another car while on Route 1, which is some sort of highway or very, very fast lane of travel. Hit the guardrail and ricocheted across the opposing lanes of travel, entered onto the restaurant premises through a parking lot, and then crashed into the restaurant. So that's what happened. So the plaintiffs in Glick sued the restaurant, claiming that the restaurant had a duty of reasonable care, and that duty made it so that an event like this would be foreseeable. And they sued. Ultimately, the defendants who were defending the restaurant in Glick did what's known as a motion for summary judgment. So a motion for summary judgment is when one side asks the court and says, Your Honor, there's nothing here. There's no case. There's no reason to let this case go forward. The plaintiff or the plaintiff, because again, the plaintiff sued the defendant, can't win this case, even if they prove everything that they're alleging within their complaint. Okay, the complaint is the actual lawsuit itself. It gets filed with the court, telling the defendant exactly what they're being sued for. So the court in Glick looked at it and actually agreed with the defendant. And the reasoning being that this type of situation was so unforeseeable that to basically require and hold this restaurant responsible for the very rare event that a car on an adjoining highway would be clipped by another car, drive across several lanes of traffic, through a parking lot, and then bury itself into the restaurant is not something that is to be expected. And that for that reason, there was nothing that the restaurant could have done differently to have prevented such an accident. A couple quotes from the Glick case that I would like to read to you guys is one where, the court, the appeals court in Mass, quotes a Florida court who dealt with a similar issue, and basically said that it is an obvious fact that at times operators lose control over the forward progress and direction of their vehicles. In a sense, all such occurrences are foreseeable. They are not, however, incident to ordinary operation of vehicles and do not happen in the ordinary and normal course of events. The consequences resulting therefrom are matters of chance and speculation. If such occurrences are held to be foreseeable and therefore to be guarded against, there will be no limitation on the duty owed by the owners of establishments into which people are invited to enter. So the court essentially agreeing with the defendants and looking at the way that other states have dealt with these fact patterns, agree with the defendants and essentially ended the case without even letting it get to a jury. And that was at the trial court level. The plaintiff appealed, went to the appeals court in Mass, and the appeals court in Mass upheld the lower court, agreeing that there was basically no case and there was it was not foreseeable that this would happen. So that was 1987. The next case that I could find that dealt with this was a little, fast forward actually to 2018, when somebody sued Cumberland Farms. Another tragic case where a gentleman was walking into a Cumberland Farms over in Chicopee, Mass, and a driver lost control near an intersection and just buried their car, and ultimately killed the plaintiff. Very, very sad case. The case did go to a jury, and the jury actually awarded $32 million, and ultimately that number was reduced. It's a little unrelated, but the distinction and the difference in this case, Dubuque versus Cumberland Farms, citation 93 Mass Appeals Court 332. For those of you who want to read it, you can just Google that. Again, 93 Mass Appeals Court 332, was that in the Dubuque case, apparently Cumberland Farms has a history of their stores being struck by what are known as moving or striking events. So I guess people like to drive their cars into convenience stores, and more particularly Cumberland Farms. I mean, there are several facts that the appeals court in this case noted that really, shed a light upon how common these actually are. One fact was that between 1990 and 2010, there had been hundreds of vehicles striking buildings at Cumberland Farms convenience stores in various locations. This is directly from the case. In each, a driver, for one reason or another, lost control of a motor vehicle, causing it to strike the building. This happens all the time, so much so that Cumberland Farms actually has a guy who works for them that purely tracks these car strikes. Literally, that's all that he does. And in 1988, these car strikes were happening at a rate of approximately 1 per week. That is a lot higher than I thought. I did not realize the number would be that high. So there was some issues with the trial judge allowing this evidence of prior car strikes to come in to be heard by the jury. In this case, Dubuque versus Cumberland Farms. Ultimately, the trial judge let it in. The jury heard all about it, and the jury ruled in favor of the plaintiff and gave an award to the plaintiff of over $32 million. Now, one of the issues in Dubuque that the court really focused on was these things called bollards. Now, bollards, for those of you that don't know, are those kind of tubes, the steel tubes that you see, outside of the front of convenience stores, and they're filled with concrete. Target has them. A lot of convenience stores have them. And there was evidence that prior to the plaintiff in Dubuque being killed, that Cumberland Farms had investigated installing these, 4-foot-high steel concrete-filled bollards in front of their stores, but ultimately decided against installing it at this particular location because this location had not met two different criteria. One, having been struck before, and two, being a high earning location. So that was not good. Apparently, safety does have a price. So those are the two cases I could find. So in this case, the attorneys who have sued Apple and the the landowner are going to really have their work cut out for them, because I think this case, from what I can tell so far, falls more in line with the Glick case, the older 1987 case, where the driver just lost control on Route 1 in Saugus and jumped over multiple lanes and then drove into a restaurant and hit people who were eating at the restaurant, versus the Dubuque versus Cumberland Farms case, where there were literally hundreds of these car strikes throughout the New England area. So if there's evidence that the developer of this land, the owner, knew about these car strikes and failed to take certain steps to, install these, concrete bollards, that might come in at trial. It might not. So I will continue to follow this story. I couldn't get my hands on the actual legal complaint. I would have loved to read it to you guys so you could see exactly what the attorneys for these victims who were injured and killed in this Apple Store case are actually alleging. I will keep you guys posted on that. So in the end, from what I can see, the Apple Store victims are going to really have to prove that this was a foreseeable event. And from what I'm seeing, I just don't think that the court's going to go that way, absent evidence that this has happened before at this location or other locations. I do notice that according to the news and the Associated Press, that apparently this particular plaza does have these bollards or other obstructions to prevent these types of strikes at other locations throughout the plaza, but just not the Apple Store. So why they do that, or why they have certain obstructions like these bollards in some places versus others, will definitely be something that the plaintiff's counsel will look into very, very heavily. They would be foolish not to. So, hope you guys enjoyed it. This was a shorter one today. I just figured I'd hop on this story, give you guys my two thoughts. If you have any questions, please feel free to email me, lawwithdarren@gmail.com. Like, comment, subscribe. You can comment on Facebook. I'll be more than happy to get back to anybody. Have a good day, guys. Be safe and be well.